Good morning. Welcome to the second session. The format is going to be mostly the same, but also different. And by that I mean that we're going to try to encourage questions from the floor as our speakers talk, because after all, this is supposed to be a two-way street. We need to let the questions come so that the experts can answer, and frankly, we always learn every time we do one of these events. My job is to try to facilitate that. I'm not a local, as you can hear from my accent. My name is Mark Baker, and I'm from Houston, Texas. I'm also a bit tired because I finished a federal court case Tuesday afternoon at 3 o'clock in order to catch the 4:30 plane. The judge gave me an hour and a half to get to the airport. And while I was at the airport, I counted up that in the 12 weeks so far that we've had in 2015, I've spent 6 of them in hearings. So if I nod off in my own presentation, that's my good excuse. We have a wonderful panel here this morning. Their bios, of course, are in front of you, but I do want to just highlight a little bit about their experience, because a very wise statesman once observed that if you show me where a man sits, I will tell you where he stands. And of course, he was referring to the House of Commons, by which side of the room he was sitting on and what position he would have on an issue. I think it helps if you understand the experience of the comments from the source of those experiences. So we'll start with Hilary, always ladies first in the American South. She's QC from London at Brick Chambers. She is extremely experienced as an advocate in both arbitration and in litigation, and frequently sits as an arbitrator in complex cases. I know because most recently she just finished a panel with several of my colleagues. Professor Shepard, of course, you met earlier this morning, and along with Larry Newman is truly the ramrod of this organization. And Ben was, before he became a professor, at the A.A. White Dispute Resolution Center at the University of Houston Law School for 20 plus years, the head of the international disputes practice at Vinson & Elkins. So he has both the professorial and the practical to bring to bear. Jim Carter next is currently at WilmerHale, but he spent most of his career as the head of international arbitration at Sullivan and Cromwell, and like the rest of the panel members, has a lot of experience on both sides of the table as advocate and arbitrator. Robert Weisner from Toronto is from Macmillan. He runs the arbitration practice as a senior partner there, and he told me he was so happy to see sunshine because he hadn't seen any in Canada in so long that they thought they'd gone into hibernation. So I'll spare you my global warming comments about that. And last, and certainly by no means least, we are also honored to have a former judge of the Law of the Sea Conference, who is now a special consultant at Curtis Millay with a specialty in state-to-state matters. And so we're delighted to have his perspective on that, and that illustrates the slight difference that we're going to try to bring to bear. Because cross-examination really has to be looked at from a variety of perspectives. There's the perspective of the counsel that are trying to achieve certain objectives. There is the perspective of the tribunal, which wants certain things out of cross-examination, which are not necessarily the same thing that counsel want out of cross-examination. And then, of course, there's the witness's perspective as well. And there's a lot of issues that still separate us about what we do to prepare witnesses, or whether we prepare them at all, and how we prepare them. So we're going to try to look at all of these issues as best we can from those 3 perspectives. So I'll ask each of our experts, when they make their interventions, if they tell us from which perspective they are speaking. And that's easy because they've done it all. And so aren't we lucky to be able to benefit from all of that? So let's start with a radical proposition to wake everybody up this morning. Here is the radical proposition. The cross-examination is a lot like sex. Now I have your attention. Why do I say that? I say that because everybody knows how to do it. Some people are really a lot better at it than others. And what we'd like to explain is perhaps why that's the case. So, let's dive right on in after I've gotten everybody's controversial attention with that. And let's talk about what is the real purpose of cross-examination. So from the standpoint of the counsel, what are you trying to achieve by cross-examination? And then let's drill down and talk about how counsel actually begin to prepare for cross-examination. Because the truth is, most cases today are done as a team effort. There's more than one lawyer involved. Sometimes there are huge numbers of teams that are involved. So how does the person who sits at the top of the pyramid go about preparing for cross-examination? Volunteers? Because otherwise I get to call on names. That's the beauty of having the mic. All right, Jim Carter, you're up.
Well, from the standpoint of counsel getting ready to prepare, you really do have a team effort. And there's a comment in the book, I've forgotten who wrote it here, that what I'm really trying to achieve overall is to convince the tribunal that my side of the story is better. Not necessarily that this witness is lying or is unreliable in his recollection. What I really want to do is figure out what really helps my whole story here. And Ben said earlier today, when he was listing all of the rules, if I can't do anything else, at least I can get their witnesses to help me tell my story by showing the arbitrators the documents that I'm really interested in. Or if I've already done that with a particular witness, then I've got a different role for the next witness who comes along. So I prepare by thinking about the strategy and then discussing with the team, where are we going to be with this witness after I see what the two or three of you who are also on the team will have done with the witnesses before that. It's all part of telling the story.
So that's a good way to look at it, telling the story. So that means that you're sitting in a conference room with your team members, and you've probably got a big whiteboard, and you've got the case themes that are written up, and then you're dividing how you're going to instruct the tribunal or teach the tribunal those themes. And cross-examination has a role to play in that, but maybe not as big a role, Professor Shepard, as we have been led to believe. And the reason I say that is because we've, in the last panel, had a fair amount of time talking about the way in which we can't have surprises in cross-examination anymore. We don't get to pull things out of our briefcase that the witness has never seen because the tribunal makes us produce it all in advance. So what about that? Is cross-examination overrated these days in telling the themes?
No, I don't think so. And I'll switch to the arbitrator perspective since you asked us to identify that. I, as an arbitrator, find the oral hearing and the cross-examination extremely helpful. And one point I hope we'll cover sometime today is the role of direct examination. And
you
that's
bet
up
we
to the
will.
tribunal. And if I may, Mark, let me open with that. I'm of the view that there ought to be, and when I'm on a tribunal, I include this in procedural order, I like to have some direct examination of the witness by the sponsoring lawyer. And
the reason for that is what?
Two reasons for that. With the lay witness, number one, I think it's only fair to allow the witness to warm to the seat. It's terribly unfair to the lay witness, scared to death, unfamiliar with the proceedings. Their company's income and perhaps their job is on the line, and to throw them into cross-examination strikes me as unfair. Secondly, as I mentioned earlier, we know the arbitrators have an encyclopedic memory. They've memorized the witness statements and all the documents. I'm not that smart. I like to be reoriented. We've got 20 or 30 witnesses, all these documents. Bring me back, what does this witness bring? And then I like to hear the witness, again, confined to the subjects in the witness statement, nothing new. I like to hear them in their own words. There's a cynical suggestion that lawyers write these witness statements. And I like to hear the witness testify in his own terms. So to me, again, answering your question, I'm looking for that direct examination is very helpful. When it's the expert witness, we were talking about this at dinner last night, when it's the forensic expert, I like to hear a full explanation by a good forensic expert of what the technical issues are. It helps me. Now, in terms of what helps, themes help, focus on the documents. What generally does not help persuade me is the ad hominem. I just don't favor the ad hominem, that is the personal attack, things that might be embarrassing to the witness or things that they might have done untoward. I really think counsel had better tread very lightly on that. I'm really interested in the case, and I'm interested in counsel's help to focus on the story.
So when you're wearing your arbitrator's hat, Ben, how much time do you think should be divided between direct and cross-examination? Would you leave that to counsel to apportion the time, or would you as a tribunal member want to have that sorted out up front?
No, I sorted out. It's in the first procedural order, and we'll sort that out at the first procedural hearing. It's on the agenda that I submit if I'm chairing or sole arbitrator, is that very question. Are we going to have direct examination? How long? And typically the amount of time, it is always specified, and it's usually something like 20 minutes. In terms of time limits, I know there are different views on this. I think Sophie Knappert mentioned that chess clocks are not that favored. I'm one who does not favor these arbitrary limits on time. I think the counsel need the opportunity, with supervision from the tribunal, of course, over time management, to present their case. So it's going to be set out 15 or 20 minutes for direct, and however long the cross takes.
So you would do that in the very first procedural order?
The direct examination would be in the first procedural order, yes.
Would you address separately how much time for cross-examination counsel would have in the same order?
No, I generally do not put a limit on the time for cross-examination, and generally, as you work through your steps leading to the hearing, including the final hearing, pre-hearing conference, you'll sort out just how long the total hearing is going to take, but not in terms of specific limits on specific witnesses or specific cross-examinations, no, because you can't know in advance.
So how about anybody else? Do you set those types of limits or those guidelines at the beginning of the case? Anybody else? Anybody in the audience want to take a shot? I think it's extremely important to set those types of guidelines up front, because good lawyers can plan for anything if they know what the rules of the road are going to be. I'm a little interested in the distinction about total time coming later, because my experience has been that most of the time the question gets sorted out at that early conference about how many hearing days we're going to have, and that's what everybody plans for. Now, what often doesn't happen is the kind of detailed division at that stage about what we're going to do. That's possibly a mistake too, because Jim, sitting with his team with the whiteboard, needs to know if he's going to have 30 minutes for a witness, or if it's entirely at his discretion, if he's going to have a total of 10 hours of cross-examination to use as he sees fit. So I think one of the things that we can all do as a planning note is focus on those issues sooner rather than later, because it tells us the kind of case that we're going to try. I heard David Haig and some of the others in the first panel draw a distinction about the importance of not only allowing direct evidence, but also making decisions about who is actually going to be crossed. And I think that's absolutely vital, because there's never time to cross everybody. The days of the luxurious, never-ending court case, which Canada hung on to longer than almost anybody, where you could have an appellate argument that went on for 24 days, as we did in one case some years back. It just doesn't exist anymore. And it certainly doesn't exist in the world of international arbitration. So let's assume that we've got our time limits. Let's go back to the witness preparation point. At what stage do you begin planning for cross-examination as counsel? Robert, you try cases.
Right. So as counsel, you begin planning for cross-examination from the very outset, I think, of the case when you're drafting your own witness's statement. You're starting to think a little bit about how is this witness going to be cross-examined. And definitely, my experience tends to be that witnesses will tell you a story and they're adamant about it. And then you have to show them this document and they say, oh yeah, well, come to think about it, might have not have been quite entirely like that. And it's better to kind of make sure that the witness has had that experience before they actually sign a statement that is going to be contradicted later on, right? So that they've anticipated this issue kind of arising and either explain it in their witness statement or they don't contradict themselves and are ready to explain it on cross-examination. So that's in terms of your own witnesses. In terms of the other side's witnesses, I think as the speaker said on the other panel this morning, you don't usually get leave unless you get some excuse to put in documents at the hearing, and you can't surprise the witness. It's not fair to them. So when you're filing exhibits with your counter memorial or with your reply memorial or rejoinder, you're thinking not just about putting this exhibit in for the purposes of the written submission, but also for the purposes of cross-examination. And sometimes there are things where you're prepared to just highlight it in writing ahead of time, let the tribunal know about this issue. And sometimes there may be documents which you file, you may not put that much of an emphasis on them in the written submission and feel that it may be more appropriate to bring it out in cross-examination. So there's that strategy that has to go on, I think, at the time that you you finish your written submissions. So I would say that 90% of the work is actually done before the hearing is even close to being held. With the remaining work being kind of done right in the run-up to the hearing.
Can you draw any distinctions in the way that you prepare witness statements for the witnesses that you'll be putting on direct and preparing for for your defense of their cross-examination versus the other where you're preparing to cross the other side's witnesses when you obviously don't have control over the direct witness preparation?
Yeah, sure. So obviously, there's preparing your own witness for cross-examination. You try to make the witness statement as conservative as possible while still getting your case out, trying not to put words in the witness's mouth in a way that the witness wouldn't say them. In terms of preparing for the other side's cross-examination, and just before I say that, obviously, I'm skipping over all the woodshedding time, as we say, that goes on right before the hearing.
For that.
Okay.
Don't skip over that. That's important.
So let's talk about that, and I'll just in terms of preparing your own witness, and hopefully I won't bore people, but there is a lot of time which you have to spend with a witness, taking them through what the process is like after they've filed their statement. So I usually start by describing the room, what the room will look like to them. So they don't walk into a room. I tell them a little bit about who the 3 arbitrators are, who opposing counsel are, and then I go through some of the general rules about being a good witness. And there's a number of articles that are published about it. David Roney has an excellent one that he published a number of years ago in the Journal of International Arbitration. And these aren't rules that witnesses need to memorize, but they're things that people should know. Sometimes saying I don't know to an answer is perfectly okay. Sometimes it's not an embarrassment, it's nothing to be ashamed about. Sometimes the answer is simply I don't know, and that's all right. Don't guess, for example.
Do you ever do mock examinations with your own witnesses?
Always, yeah. So after the rules of being a good witness, you tell them what the issues in the case are, generally what issues will be covered, and you give them a little bit of a flavor on you don't do I don't find I have the time usually, or there's enough in the dispute to justify spending a whole day on a mock cross-examination, or bringing in one of my partners to do the mock cross-examination. That would only be for a very high-value dispute, but you certainly give them a flavor of what it's like, and you can just do it for a few minutes, and they get the sense all of a sudden that, oh, this is not going to be just like a conversation that you might have over dinner with someone. It's something you have to think about when you provide your answer. So I think some mock cross-examination, not a full one covering every single issue in the case, is necessary.
Hilary, let me ask you this. You, as counsel, ordinarily do not assist, I take it, in the preparation of witness statements for people in your own case. Is that correct?
I mean, the rules have slightly changed since I've been at the bar. One time it was all very strict and one couldn't talk to witnesses, etc. Now in international arbitration, we don't usually draft the first statement, but certainly we will assist in settling it. I mean, usually I come in to sort of lead up a team or work through solicitors, because we have a split profession in London. But undoubtedly we do get involved these days in making sure the witness statements are drafted properly, because that's such a key element of the case. So no longer do we just come in and have a piece of paper handed to us, because it's very important to make sure that the documents are dealt with, that there aren't inconsistencies, that there aren't hostages to fortune, and the witness needs to look at all this. And so we definitely are involved in it.
But what about in court?
In court, well, again, yes, but less so, because in a court, a lot more work will have probably been done by a solicitor. But again, the rules are much more relaxed than what they were.
So does it bother you in your capacity as wearing your arbitrator hat that witness statements are never drafted by the witness?
It doesn't bother me. It's something that one recognizes, and I think some of you I've told the story to quite recently. When I was sitting as an arbitrator, there was cross-examination of a witness trying to stress how much importance its witness, according to the cross-examiner's case, wrongly had put on a point. And he pointed to the fact that in the witness statement, the words had been typed in bold typing, and the witness sort of looked completely blank, at which point I said, I think that may not be something that was initiated by the witness, at which point the cross-examiner moved on. That's the sort of subtlety which is put in by a lawyer, quite obviously, and experienced lawyers know that. And so that sort of cross-examination is a complete waste of time.
Now that the IBA rules have made it clear that witness preparation of at least some sort is okay worldwide, do we still have anyone in the room that has questions about that preparation process and where we draw the line? That's usually a topic that gets a lot of interest in the civil law, common law divide, because in my jurisdiction, it would be virtual malpractice not to prepare your witnesses in the most full and fulsome manner that you possibly could. And as Robert has alluded to, in a high-value case, that includes mock cross-examinations and videotaping of witnesses so they can see what asses they made of themselves, so that hopefully they won't do it when it really comes time to make it happen. And that's been standard in American and Canadian courtrooms for a long time, and it has been in international arbitration too. But until very recently, and in fact in many jurisdictions in the EU, in court cases, that is completely impermissible, this being one of them, Austria being another particularly celebrated one. And a lot of those practitioners don't really feel comfortable even with the internationalization of the dispute practice, and particularly about where to draw the line. So are there any questions about that from the floor? Because I assure you, everybody up there has done one or more cases in jurisdictions where it would not be allowed in court cases. John?
I'm John Kedelberger from Stockholm. Another question is, how often did you see witness statements not prepared by counsel or even drafted by the witness themselves? And what impression would that in such a case make on you as a tribunal?
Anybody want to take a shot? Hilary, your mic's on.
Well, I haven't come across it as an arbitrator in recent years. In a sense, it would be a pleasant surprise to hear the evidence directly from the witness. I'm afraid it's taking a witness through their full evidence in direct is a dying, if not dead art. But certainly when I first started at the bar, it was always regarded, in fact, as a more difficult exercise than preparing cross-examination to get your witness to tell the story. These days, it's all drafted by lawyers, and you get some silly cross-examinations like the one I mentioned to you earlier. Just on a separate point about preparation, one thing I have noticed quite a lot of these days is in big value cases, both court and arbitration, lawyers are sending witnesses to specialist training. We have various people who do it in the UK and I'm sure in the States as well, to give them the feel of what it's like to be a witness. And I think overall that's proving to be quite valuable, particularly with a nervous witness or a witness who hasn't done it before. They teach them the basics, like to speak up, and the points that Mark was making earlier. If you don't know the answer, say you don't know. If you don't understand the question, ask again. These sort of basic things, but they're taught in a professional way.
So let me put the... Oh, I'm sorry. We have another question? Yes, please. Thank you, Ben.
Yes, thank you. My name is Pauline Permiko. I'm also from Stockholm. Witness preparations, when it comes to mock trials and trainings of the witnesses that you just mentioned, I think in Sweden it's not very common, even for very large cases, that you would do mock trials, especially if the trial is based on the case documents. But once in a while you see witnesses that have been prepared in this way, and it may be witnesses that a company chooses and uses them in other cases if there are reoccurring cases. So my question is there really a point in having those witnesses? How much, to what extent a witness testimony given by a very well-prepared witness, which basically becomes a lawyer, can be perceived as a truthful and reliable testimony and not a testimony given by a hired gun?
Well, let me ask you the following question first. Does the story come out better from an ill-prepared witness that knows nothing about the documents but is brought there because they're a senior company officer that's easily embarrassed by a cross-examiner? In other words, the flip side of your concern about a professional witness, which one, maybe neither, advances the ball for the tribunal?
I guess my point is that the witnesses should help the tribunal to understand what has happened, and if you see a witness that is trained to give a particular picture of an event, this may not be a reliable testimony from the beginning.
Could also be really fun for cross-examination if you were aware of the last 5 times that that witness had testified, to the point that Brother Newman was making in the first session. Yes, we have another question here.